Good morning. Subcommittee on Intellectual Property, Competition, and the Internet will come to order. I'll recognize myself for an opening statement. Our subcommittee had much to celebrate following passage of the Leahy-Smith America Invents Act, or AIA, the most comprehensive change to American patent law in 175 years. The AIA addresses a number of issues. The dynamic that compelled our subcommittee to debate patent reform for 6 years was the prevalence of frivolous patent suits that drained resources from R&D projects and compromised job creation in several industries. I am confident that several of the AIA reforms, such as post-grant review, changes to joinder in U.S. District Court litigation, and a transitional program to scrub business method patents, will rid the system of many of these bogus lawsuits. One would think that such a legislative accomplishment obviates the need for the subcommittee to conduct additional patent review in this Congress. Unfortunately, that is not the case. Today's hearing focuses on the operations of the International Trade Commission, or ITC, and how that organization handles patent disputes. Increasingly, many high-profile patent disputes are adjudicated before the ITC. The Commission is an independent, quasi-judicial government agency that provides nonpartisan counsel to the legislative and executive branches of the government. It assesses the impact of imports on U.S. industries, maintains the harmonized tariff schedule of the United States, and oversees actions against certain unfair trade practices, including subsidies, dumping, and patent, trademark, and copyright infringement. As part of the Trade Act of 1974, Congress created the modern ITC along with its main attributes: independence as a federal agency, final decision-making authority, subject to a presidential veto, the power to issue cease and desist as well as exclusion orders, formalized coverage of unfair trade proceedings by the Administrative Procedures Act, or APA, and a requirement that the Commission issue decisions with dispatch. Agency proceedings regarding patent infringement are governed by Section 337 of the Tariff Act of 1930, as well as the adjudicative provisions of the APA and the Commission's procedural rules that are typically supplemented by ground rules issued by the presiding administrative law judge. Section 337 declares the infringement of certain statutory intellectual property rights and other forms of unfair competition in import trade to constitute unlawful practices. Most Section 337 investigations involve allegations of patent or registered trademark infringement. To be successful, a complainant must prove the following elements. First, the existence of unfair methods of competition or unfair acts in the importation of articles into the United States. For patent cases, infringement of a valid U.S. patent constitutes an unfair act. And second, the importation of articles or the sale of such articles in the United States, the threat of which is to destroy or substantially injure a domestic industry. This also includes preventing the establishment of such an industry or restraining or monopolizing trade and commerce in the United States. Remedies for Section 337 violations generally consist of either a limited exclusion order that is directed to a respondent specifically found to have violated Section 337, or a general exclusion order that applies to all infringing goods, whatever the source. A general exclusion order has sweeping application and therefore requires a complainant to demonstrate that the remedy is necessary to prevent circumvention of a limited exclusion order, or because there is a pattern of statutory violation and it is difficult to identify the source of the infringing goods. Prior to the Supreme Court's 2006 decision in eBay versus Merck Exchange, the issuance of injunctions in patent disputes was almost automatic. But the Court's ruling that the traditional four-factor injunctive relief test applies equally to patent disputes now means that a patent holder has, on average, a 1 in 3 chance of securing an injunction from a U.S. District Court. By contrast, a patent holder who prevails in the ITC is virtually guaranteed to obtain an exclusion order, the functional equivalent of an injunction, absent truly exceptional public interest concerns. This has become of great interest to patent trolls who do not commercialize their patents. eBay restricts their access to injunctive relief in U.S. District Court, but it is technically possible for them to fulfill the domestic industry requirement of ITC adjudication through licensing activities. The advent of globalization has led to a migration of manufacturing resources from the United States to other countries. This reality, combined with particular elements of ITC practice, has made the Commission an increasingly attractive forum for all patent holders to defend their property rights. In fact, the average number of ITC complaints filed annually during the past decade is nearly triple the average for the previous decade, and at least one study indicates that many of the complainants are larger firms with multiple product lines and valuable patent portfolios that have a better chance to win in the ITC than in U.S. District Court. However, according to some reports, over the past half-decade, we have also seen a dramatic increase in the number of cases brought at the ITC by non-practicing entities, as well as the number of defendants named in these cases. The number of defendants in these cases grew from 22 in 2010 to 232 in 2011. This begs the question of whether certain parties are flocking to the ITC in the wake of the stricter joinder rules and other provisions enacted as a part of the America Invents Act. Given the Commission's burgeoning and high-profile caseload, it is a good time for our subcommittee to conduct an oversight hearing about ITC operations and how the agency handles patent disputes. The scope of the hearing is free-ranging and will address any relevant topic, but the subcommittee will certainly want to address such issues as whether ITC rulings complement or conflict with U.S. District Court decisions, how the ITC treats standard essential patents, how a plaintiff satisfies the domestic industry requirement of an investigation, and whether exclusion orders are too cavalierly granted. That concludes my opening statement, and I now pleased to recognize the ranking member of the subcommittee, the gentleman from North Carolina, Mr. Watt.